My Lords, I would like to add my voice to that of the Noble Lord Collins before I turn to my own all-party genocide amendment. But I would like to say that his proposition that great thought must be given to a more coherent and comprehensive approach in dealing with gross violations of human rights is the right approach. It's always a privilege to follow the Noble Lord because many of the same issues motivate and animate the two of us, and it's always a privilege to speak in your Lordship's House about these issues. As co-chair and co-founder of the All-Party Parliamentary Group on North Korea, I gave evidence to the United Nations Commission of Inquiry into human rights violations in North Korea. 6 years ago, it found North Korea to be, I quote, a state without parallel. Its crimes were found to include, I quote, extermination, murder, enslavement, torture, imprisonment, rape, forced abortions and other sexual violence, persecution on political, religious, racial and gender grounds, the forcible transfer of populations, the enforced disappearance of persons, and the inhumane act of knowingly causing prolonged starvation. It concluded, my Lords, that these crimes are ongoing because the policies, institutions and pattern of impunity that lie at their heart remain in place. It concluded that crimes against humanity had been committed and recommended that the Security Council request the International Criminal Court to initiate a prosecution. That, my Lords, has never happened because, as the United Kingdom repeatedly says, China would use its veto to prevent a referral to the ICC. And that is on the issue of crimes against humanity and human rights violations, my Lords, even before one comes to the crime above all crimes, the crime of genocide. We, of course, should challenge the ability of any country to use a veto when human rights violations of this magnitude are found by a commission established by the United Nations itself. But, my Lords, there is no treaty obligation to prevent even crimes against humanity. But there is on genocide, hence this amendment that I have laid in you before your Lordships today, and on which I will seek the opinion of the House later. On Thursday last, I spoke during the proceedings on the Telecommunications Bill, and I was grateful to the Noble Baroness Lady Barron for responding so positively to many of the points which I and other Noble Lords have made to her, and it was possible, therefore, not to have a division as a consequence of that. During the course of that debate, I outlined some of the appalling atrocities which the Noble Lord Collins has just referred to and which have been occurring in Xinjiang. It's an issue which I first raised in your Lordship's House in 2008. And, my Lords, I'm Vice Chairman of the All-Party Parliamentary Group on Uyghurs and follow this on an almost day-by-day basis. This genocide amendment has its origins, though, not in China or in Xinjiang or the Uyghurs. It has its origins in 2016, when, despite Parliament passing a motion on genocidal crimes against Yazidis and other minorities, the government refused to accept it because a court had not made the declaration. The All-Party Genocide Amendment remedies a circular argument. It also supports the position of successive governments that only a court has the authority and ability to make such a determination. For at least a generation, the policy of all governments has been that genocide determination is a matter for the courts and not politicians. My Lords, Boris Johnson, the Prime Minister, at Prime Minister's question time on the 20th of January said, quote, "The attribution of genocide is a judicial matter." Dominic Raab, the Foreign Secretary, on the MAR programme on January the 17th said, "Whether or not it amounts to genocide is a matter for the courts." Boris Johnson, as Foreign Secretary on the 21st of November 2017, said genocide is a strict legal term and we hesitate to deploy it without proper judicial decision. The United Kingdom reviewed this policy in 2016 and the then Prime Minister, David Cameron, concluded, quotes, "It's not for the government to be prosecutor, judge and jury. Not only are the courts the best place to judge criminal matters, but their impartiality also ensures the protection of the United Kingdom government from the politicisation and controversies that attach themselves to the question of genocide." My Lords, this is in contrast, of course, with the United States and other jurisdictions which have made non-judicial or political determinations of genocide, the latest of which was the designation by the outgoing US administration on the 19th of January last regarding the treatment of Uyghur and Turkic Muslims in Xinjiang. that it was reaffirmed the following day, my lords, by Secretary of State Antony Blinken in the incoming administration, so a bipartisan view. The government accepts that the present process in the UK is not fit for purpose. Yesterday, at a meeting of peers, which was addressed by 3 government ministers, and many of those present in your lordship's chamber today will have heard this, they said that they intend to offer a concession to turn the policy of 40 years on its head and allow select committees to consider whether a genocide, as defined under Article 2 of the 1948 Convention on the Crime of Genocide, is underway. Respectfully, my lords, and I say this as a member of your lordship's International Relations and Defence Select committees already have such authority to examine evidence of genocide if they wish to do so, and do not need legislation to give them that power. Members of the House of Commons Select Committee on Foreign Affairs have already expressed public opposition and scepticism about this proposal. If, however, my lords, an approach were to include a legislative right, for instance, for a committee not only to examine the evidence, but also to be able to trigger a referral to the High Court, this would not only open a judicial route, it would also enable parliamentary scrutiny and provide a trigger mechanism. An otherwise toothless concession might then be given some teeth. This afternoon, my lords, 2 of the 3 ministers who were present on that call yesterday, and the Noble Lord Grimston was one of them, 2 of the 3, though interestingly not the Foreign and Commonwealth Office, and Lord Armid of Wimbledon's signature was not on this letter, but a letter came to us rather belatedly at lunchtime today, a letter to all peers. My noble friend, Lord Hannay, who knows a thing or two about foreign affairs, has emailed me, and he is supporting the amendment before your lordship's house, but he says this about the letter that we have been sent. It seems to me that the letter makes one fundamental error when it says that your amendment, that is the amendment before your lordships, is designed to get a British court to rule on whether country X or Y had broken its obligations under the Genocide Convention. It's surely aimed at getting a British court to rule as to whether the British government would or might be breaking our obligations under the Genocide Convention if it were to conclude a trade agreement with country X or Y in the light of evidence about their genocidal actions, close quotes. My lords, my noble friend Lord Hannay is right. The amendment doesn't seek to convict a country through the courts, and therefore many of the windmills that the noble Lord Lord Grimston invited us to tilt at earlier on are imaginary windmills, and we don't need to be like Don Quixote in that respect. This amendment does not provide for a criminal prosecution. Lord Hannay is right when he says that the purpose of the amendment is to enable the United Kingdom to fulfil its obligations under the Genocide Convention. At report stage, this amendment received a majority of 126 in your lordship's house, and the government, which has a large majority of over 80 in another place, had a majority of 11 when the amendment was considered there. It is greatly welcome that the government are beginning to address the issue and to offer some way forward, and I'm grateful to the Minister and their teams. Of course, though, my lords, the only way, as the noble Lord Collins has just reminded us, the only way that such concessions can be agreed is by us today voting to send this amendment back to the Commons. Otherwise, the amendment will die in the ditch. When government ministers now say they don't want the courts involved and question the ability of the courts to deal with such questions, they should consider that among the supporters of the amendment before us today are 2 illustrious former Lord Chancellors from both sides of the House, the noble Lord Mackay of Clash Fern and the noble Lord Faulkner of Thoroton. Other supporters include 2 former Supreme Court judges, the former Lord Chief Justice, and a range of Queen's Counsel, including Lord Carlisle of Berriew, Lord Panic, and the noble Baroness Lady Kennedy of the Shores, who is in her place, and we'll all look forward, as ever, to hearing her speak in this debate. The government can hardly plausibly argue that the amendment is therefore legally defective or incapable of operation. At yesterday's meeting, ministers said the amendment, and I quote, may frustrate foreign policy and create diplomatic difficulties. Diplomatic difficulties, my lords. We're talking about genocide, not diplomacy. It's designed to frustrate business as usual on the narrow and specific issue of genocide and to honour our obligations spelt out in international law in the Genocide Convention. Senior figures from the world of foreign affairs are appalled by that extraordinary argument from the government. Encouragingly, the amendment is supported by 2 former Conservative Party Foreign Secretaries and the former leader of the Conservative Party, Sir Ian Duncan-Smith, along with the front benches, as we've heard from the Noble Lord, Lord Collins, and we will hear, I think, from the Noble Lord, Lord Purvis, later in the debate from the front benches of the opposition parties. I might add also the chair of the Foreign Affairs Select Committee in another place. Outside the House, it's received important support from the Board of Jewish Deputies and the Chief Rabbi, the Muslim Council of Great Britain, UK humanists, Anglican and Catholic bishops, the International Bar Association, and a range of human rights organisations. In response to issues raised during earlier stages of consideration, the movers of the amendment listened carefully and have responded to the argument about the separation of powers, a point made by the Noble Lord, Lord Lansley, during our report stage debates. We listened to that argument and have tabled this revised amendment in lieu. In accordance with their wishes, it therefore reserves to the Executive and Parliament the final say about what action to take on trade arrangements once a preliminary finding has been made by the court that there is evidence of a state, whatever state it may be, being complicit in genocide. My lords, this isn't a theoretical argument. It's borne out in a written reply given only yesterday to my noble friend Lady Cox. It was an answer from the Noble Lord, Lord Grimstone. He said this, I quote, "China is an important trading partner for the UK and we are pursuing increased bilateral trade." We are pursuing increased bilateral trade. Ministers have been saying previously that this amendment wouldn't help Uyghurs, for instance, because currently, and I emphasise the word currently, they have no plans to negotiate a free trade agreement with China. But, my lords, the wording on the amendment is not limited to free trade agreements. It specifically says bilateral trade agreements. Is the government really arguing that we have no bilateral trade agreements in force with China? Because that is not what Lord Grimstone said to my noble friend yesterday. On Thursday last, I set out one example of where a court might determine that the high threshold of the 1948 Convention might be met, and cited the example of Uyghur Muslims in Xinjiang. The amendment makes no mention of China, and it originates from those attempts by the Noble Lord, Lord Forsyth, the Noble Baroness Lady Cox, the Noble Lady Kennedy and myself to have the atrocities against the Yazidis declared a genocide, something which, as I said earlier, Her Majesty's government said at the time could not be done because it's a matter for the courts. None of which should blind us to what is happening to 1 million incarcerated people in Xinjiang. Our inability to say the same as the United States, something which the Prime Minister himself once said baffled him, his word, we can help him out of his bafflement by passing this amendment today. My lords, no one can seriously believe that the Chinese Communist Party is about to refer itself to the International Criminal Court for an examination of potential genocide. So the convenient but hollow argument that an international court will make such a declaration leaves us derelict in our obligations under that convention. When you hear evidence of a state complicit in the destruction of a people's identity, complicit in mass surveillance, complicit in forced labour and in forced slavery, complicit in the uprooting of people, the destruction of communities and families, the prevention of births, the ruination of cemeteries where generations of loved ones have been buried. When you hear of people being re-educated to believe that you, your people, your religion, your culture never existed, and the certainty that through ethno-religious cleansing you'll simply cease to exist, this needs the full authority of a judicial hearing, which would also put us to the fore in defending a rules-based order, global Britain, if I might say so, at its best. My lords, this all-party amendment enables us to lead by example and to be more vociferous in encouraging like-minded nations to take their convention duties seriously. It's important to be clear what the amendment does not do. It does not empower the court to carry out a criminal prosecution, but simply to establish whether it's found sufficient evidence to say that atrocity crimes meet the criteria set out in Article 2 of the Genocide Convention. It does not take decisions about what happens when it finds there's evidence of genocide. It leaves it entirely to the Executive and Parliament. It does not overturn 40 years of government policy, which has always been that genocide determination should be left to the courts. It complements it and fulfills it. It doesn't stop the UK from continuing to try to put evidence before the International Criminal Court, futile as such attempts have proved to be hitherto. Indeed, it would provide impetus and a sound legal basis for so doing. It does not reopen historic cases of genocide. It's not a futile gesture or virtue signalling. It applies to all states with which we have bilateral trade deals, including, for instance, China, but could only be invoked when the court has established evidence of a genocide. As I've said, the wording of the amendment is bilateral trade arrangements, not free trade agreements. It's not the intention of the movers that the amendment be limited to free trade agreements. It would include other such trade agreements, and yes, we have numerous such agreements with China. I reiterate, it will then be up to Parliament and the Executive what it wishes to do about such trade with states found to be complicit in genocide. Let me come towards the end of what I want to say to your Lordships. Those opposing this amendment ask a perfectly legitimate question, as the Noble Lord Grimstone has done today, about whether our courts would be capable or be the right place for doing this. It's deeply frustrating, as the noble the Earl of Caithness said earlier in our proceedings, that we've been unable to hear the voices of many who, if they could have been physically present, would have been able to deal with this question far better than me, none more so than the wise and authoritative counsel of my noble and learned friend Lord Hope of Craighead, a former First Deputy President of the Supreme Court and previously the Second Senior Lord of Appeal in Ordinary. He has made it abundantly clear that the amendment is sound and capable of implementation. At report stage, he told the House this: any idea that this is not a matter for the courts really is misplaced, adding that the existing enforcement mechanisms on the crime of genocide are simply not up to the job, and that as a consequence, the objectives of the Genocide Convention, quote, remain largely unfulfilled, and we have to face the fact that the international institutions are falling short too. On the competence of our courts to deal with the crime, he says, courts are well used to hearing and drawing conclusions from evidence. So in principle, the task of addressing whether there is or has been genocide should be well within their grasp. He says that the amendment in view, quote, looks very good to me, and he believes our decision to refer to the definition in the Genocide Convention removes the risk of there being a dispute about what constitutes genocide for the purposes of the application. And the noble and learned Lord Wolfe said in an email to me that courts will apply the facts before it to the question and say whether or not they constitute genocide. I was speaking yesterday to the meeting of your Lordships, Sir Geoffrey Nice QC, who was lead prosecutor at the trial of Slobodan Milosevic in The Hague, said that our courts and lawyers are not only perfectly competent to examine the evidence and determine whether a genocide is underway, but that many senior figures within the judiciary feel passionately that the failure to declare genocides makes a mockery of the Convention duties. Sir Geoffrey has received 80,000 pages of evidence. Xi Jinping says, and it appeared in a leaked document, that his officials should show no mercy to anyone who disobeys the edicts in Xinjiang. And an official said on television, break their lineage, break their connections, break their origins. This amendment is deliberately, therefore, specific and narrow. In the hierarchy of crimes, genocide is in a league of its own. Anyone who has stood alongside mass graves or genocide sites in Rwanda or Iraq, as I have, or visited the charred remains of homes and villages in genocidal attacks in Burma and Darfur, as I have, knows that the calculated intention of this heinous crime is what marks it out, even beyond the other horrendous crimes against humanity and human rights violations that have been referred to. Perhaps one day there will be a treaty and convention duties for these other egregious crimes, but unlike genocide, there is not. That is the benchmark for this amendment, and its precision is what has enabled many parliamentarians who would be reluctant to support a broader approach to support this one. One person watching our debate today is a Uyghur musician who speaks powerfully about persecution in Xinjiang. She spoke at the briefing held yesterday for your Lordships. The harrowing testimony of Rahima Mahmood, translated from the Uyghur language, is courageous and harrowing. These personal stories are rare glimpses into the tightly controlled and secretive world of Xinjiang, which one British academic has described as a creeping genocide. Yesterday, she pleaded with us to name this crime for what it is, but it remains the crime that dares not speak its name. Having shared her story with the chief rabbi, Ephraim Mervis, he wrote this about his encounter with her. An unfathomable mass atrocity is being perpetrated in China. The responsibility for doing something lies with all of us. I can no longer remain silent about the plight of the Uyghurs, and nor, my lord, should we remain silent. We who have the privilege to speak, we who have the privilege to act. Let me end. I've probably wearied your lordships for too long. Last week, we commemorated the 75th anniversary of the liberation of Auschwitz. As a young boy, Judge Thomas Bergenthal was incarcerated at Auschwitz. He survived. Judge Bergenthal throws down this challenge to each of us. The human mind is simply not able to grasp this terrible truth. A nation was transformed into a killing machine programmed to destroy millions of innocent people for no reason other than that they were different. If we humans can so easily wash the blood of our fellow humans off our hands, then what hope is there for sparing our future generations from a repeat of the genocides and mass killings of the past? One cannot hope to protect mankind from crimes such as those that were visited upon us unless one struggles to break the cycle of hatred and violence that invariably leads us ever more suffering by innocent human beings. This all-party amendment is a modest attempt to break the cycle of hatred and violence which will otherwise lead to more suffering by innocent human beings. It's why the House should support it. I hope we will send it back to the House of Commons for their further consideration, and when we come to vote, I will press it to a division, and my lords, I commend it to the House.